I'm thrilled to be co-presenting with Mike Geroe. Mike is a trademark attorney and intellectual property attorney. I'm going to let you, Mike, just maybe talk for a minute or two about your practice, and then we can talk a little bit about what we're going to be talking about, and then we'll jump into it.
Sure, absolutely. Thank you, Pete. I've been practicing law for about 25 years. I've been in private practice in Washington, D.C., with a New York-based law firm, and in California. Now I'm currently living in Southern California, where I have my own practice. I'm also of counsel to a Florida law firm, so it gets confusing. But my areas of expertise are commercial transactions, intellectual property, and dispute resolution. And there is a lot of activity and interest in intellectual property and how to protect it. And it's not necessarily as complicated as one might think. So I look forward to looking under the hood of those issues and sort of demystifying them with you as to their relevance for branding, logos, etc.
Perfect. Yeah, that's so important. We so value smart guys like you who know your area of expertise really well and can help those of us that are running businesses get a better appreciation for what's involved and what we need to be concerned about and what we don't need to be concerned about. And then after you've had a chance to do that, I'll jump into a little bit about how we use trademarks and other types of IP to help us tell our story better, which is really important. So let me go ahead and share my screen. I'll be advancing on behalf of Mike. So we'll be talking a little bit between us about that. But hopefully you see my screen. Let me know if you do, if you don't.
Yep.
Okay, perfect. All right, so we're talking about trademarks and other intellectual property from a branding and legal perspective. And I'll advance to the first screen and let me just pull up each of those three. And I'll hand it over to you, Mike.
Yeah, so really there's four types of intellectual property. The three registrable ones are what you see on the screen: trademarks, copyrights, patents. But a huge one, particularly for Atlanta, where Coca-Cola is headquartered, is proprietary business information, referenced as trade secrets. And probably I should have referenced that as a fourth bullet point, but it is in a category that is separate because unlike the other three, trademarks, copyrights, and patents, it is not something that you register with any government. You do the opposite. You keep it a very close secret, like the recipe to making Coca-Cola. And there are strategy considerations for whether you want to register something with the government or not. Now, for a brand or a logo or a title, it's really going to be a trademark. A patent is an invention of anything non-obvious under the sun. It's not really a sentence or a collection of words. A patent can be an idea, a business idea or a business process, but we're probably not going to focus too much on patents in this discussion. They obviously play a very important role in intellectual property, but for branding and logos, you're primarily looking at trademarks. Copyrights as well are distinct from trademarks in that a copyright is really a original literary work, or as it says, an artistic production. It's not a specific word or term or symbol. So when you are using, when you come up with a logo or you come up with a brand, that's something that you want to be able to exclusively use in the marketplace, you would register a trademark. There's also service marks, which are a special type of mark for a service, but again, to keep things simple, we'll just reference these as trademarks. And before we go to the next slide, one final point I'll add is there are so-called common law trademarks, meaning if you use a mark, if you use a logo in your business and have done so for years, perhaps, but have never registered it with the government, you may still have protection for that is recognized under law. In order to have those rights recognized, if you get into a dispute, you're going to have to go to a court and you'll have to ask the court to enforce those rights. Those rights will differ depending on what state you're in. It's going to be governed by state common law. So if you live in Georgia versus living in New York, your rights may be different. And if you use that mark in more than one state, it's going to start to get complicated. The way to cut through the complication, to simplify your monopoly right, really, to use your mark in the marketplace is to register it with the government. And that, I think, is a good segue to the next slide.
Okay, and as we're doing that, I do want to let everyone know we will have Q&A at the end. And I know personally, I'd like to learn a little bit about service marks because of the industry that I'm in. So maybe you guys will benefit from that as well. I imagine others who see this will. I think that's the advance of the second slide. So back to you, Mike.
Yeah, thank you. And the quick answer to your question is you're going to be applying for a mark. It's going to be the same. You fill out the same form. It's just that because the mark is referencing a service as opposed to a widget, it's technically a service mark and not a trademark. But that's more of an academic distinction that isn't going to have practical impact.
Okay. Thank you for that.
The big question is how do you get one of these?
Yes.
We talked a little bit about common law versus registered and state law versus federal law. When you register your trademark with the United States Patent and Trademark Office, you will be the beneficiary of federal trademark law, which again, formally it's the Lanham Act. That's not what's important. What's important is as of the date you have applied, once your application is approved, you will have protection for like 20 some years. You'll have to take some steps to maintain that protection. You'll have to go back after, I think there's a 5-year mark and a 10-year mark, basically every 5 years, to notify the trademark office that you're still alive, you're still using the mark in commerce. You'll have to give them some evidence of that. And you'll have to pay a maintenance fee, which is a relatively small fee. We probably, the next slide again, will dig down deeper into that. But basically, you will be given a unique registration number. And if anybody is using your mark or uses your logo that in a way that you think is confusing or similar, and maybe infringing on your mark, you simply send them a letter that says, hey, I'm the owner of the mark Brand Alive, registered with the United States Trademark Office under registration number 12345. It's been registered since January 1, 2010, and you're in violation. That's called a cease and desist. You demand that they stop using it. You might ask them to make an accounting of explaining to you how they used it, how often they used it, who they showed it to, and you may be entitled to some sort of compensation or settlement with them if their use has caused you any type of an economic harm. So let me see, I say here, Trademark Office. Yeah, the Trademark Office is part of the United States Patent and Trademark Office. There's a distinction here with going back for a second to copyrights, because the Copyright Office is actually part of the United States Library of Congress. And that's because literary works that are usually protected by copyright are filed and stored at the Library of Congress. So you can purchase or assign your marks, meaning if Brand Alive is getting into a business deal with some other branding company and they want to purchase your trademark, you can sell it to another business. And that would be an assignment of your registered mark. There's a formal process to do that, that again is going to be reflected in the business terms you would negotiate with the other business. And then you would record that agreement with the Trademark Office. There's a process for recordation, and like everything else we've talked about so far, that it will occur as of a date certain, and it will be filed publicly with the Trademark Office, so anyone can go and look at it and confirm it.
Just a quick question I had. Others feel free to jump in, but when should I protect my trademark by filing in my state versus in federal, in the federal, I guess, courts?
Mm-hmm. Well, that's a great question. So you don't file your trademark at the state level at all. There's no way to do that.
Okay.
There are, laws written in every state under the state constitution, in state statutes adopted by the state legislatures, and some of those statutes will apply or may apply to trademarks. If they do not, and there are some states where they don't, the courts themselves may have created law within the court system where two people have a dispute, they can't resolve the dispute, they sue each other, and the court issues an opinion. That opinion becomes part of something called common law. So a common law trademark is a trademark that is protected through the judicial branch. There's the executive branch, the legislative branch, and the judicial branch of government, both at the state and federal levels. And the judicial branch of the government has common laws that differ by state and issue some level of protection to trademarks. there's no cost unless and until you want to enforce those laws. And it does become sort of confusing and expensive, because if you want to enforce your trademark in that manner, you will have to show evidence of how you used the mark, when you used the mark, and expose that to the opposing counsel's, the opponent's interpretation of that evidence. So you can be cross-examined in court, and they can ask you, how do you know? You say that this was first used August 1, 2010, but how do you know it's not 2020? How can you prove this was used 10 years ago? And in contrast, if you have a federal trademark, you just go to uspto.gov and you can look it up in the database. There's a record of when the trademark was issued and what the registration number is. And so a lot of the fighting about, what does the trademark cover? When was the trademark issued? All of those types of debates are taken off the table by having a registered federal trademark. And the time at which you want to register that trademark is before anyone else. As long as you register it before anyone else does, you are in a pole position.
Perfect. Thank you so much for that.
You bet. So yeah, next slide. Oh, international. I could comment quickly about
please.
International trademarks. The United States is part of a multinational agreement that is referred to as the Madrid Protocol. Not every nation in the world, but many nations, particularly Western nations, are members of the Madrid Protocol. And actually countries come and go with their membership. So you can file a single application. It is a little bit messy and it is definitely expensive, but very recently I dealt with a Florida company. The founder was from Colombia, and he was doing business in Colombia, and he wanted his marks registered in Colombia. So, you can do that by individually working with the Colombian equivalent of the trademark office of the United States Trademark Office. Every nation has their equivalent of that. Or you can sort of fill out a common application. If you have kids who are applying to multiple universities, you will have heard of the Common App.
Yes.
Well, they do that for trademarks too. And it's about as Swiss cheese, meaning the Common App really isn't that common because chances are most of the universities have additional questions. Same with the trademark offices. There's always a little bit of exceptions, but it's more than zero. And if you are on a tight budget and you're adhering to the 80-20 rule of trying to get 80% of the protection but spending 20% of the time and budget, the Madrid Protocol is a good way to go. So.
Henry, it looks like Henry Rosario has raised his hand.
Yeah, sure, please.
Henry, please go ahead.
Yeah, thank you, Mike, if you don't mind. So I filed, I think, maybe 4 trademarks, and then immediately got all the spam emails from all these law offices offering different services or whatever. And one of them has been consistently like, you only have 6 months or something until you're a priority filing for your international trademark status. I was wondering if you could speak a little bit about that and how, I don't know, authentic it is. And also if you're worried about the main violation of a trademark coming from China. I don't know if they're part of the Madrid Protocol, but I guess would you recommend still doing the common app or trying to register specifically in that country?
All right. Well, so great questions. As I mentioned before, one of the powerful benefits of a registered trademark is that anyone in the world can go to uspto.gov and look up a trademark and information about the trademark. Now, it turns out that part of the application, the trademark application process itself, is also public. And that is how and why different service providers may look for publicly available information about trademark applications and offer their services. Because whether you are applying for a trademark or a patent, the role of the government is the same, and it's sort of twofold. The first is to maintain sort of this open book or record of who owns what when. But the second is to make sure that everyone who is sort of let into the sandbox is playing by the correct set of rules, which is a polite way of saying it is their job to reject your application, if at all humanly possible. They will look at your application, find as many reasons as possible to reject it. And that process of applying, getting the rejection, responding to the rejection is something called prosecution. So there's trademark prosecution as well as patent prosecution. And these rejection notices or letters that you would get in the normal course, it is not unusual to get a rejection from the trademark office. They're called non-final rejections. And a negotiation will ensue between the applicant and the trademark examiner or patent examiner that will generally serve to narrow the scope of the trademark or patent. As you indicated, Henry, you have months, generally 3 months, two or 3 months to reply to a notice sent by the trademark office. And sometimes it's more, sometimes it's 6 months. It depends on where you are in the prosecution process. As to your second question, is it better to go directly to the foreign state you care about, foreign nation you care about, and have your trademark protected there? If the answer is generally yes. If you are working in a specific foreign jurisdiction, China's a great example, or Japan, Vietnam, et cetera, elsewhere in Asia, and you care about a specific mark in that market, you are far better off to work with local trademark counsel there and see that your mark is protected. The Madrid Protocol approach is really better if you want to have initial protection in, I don't know, say a dozen, literally like 12 or 15 markets, but you don't have time and budget to perfect your application in each one of them. You want to do it as quickly as possible and as low budget as possible. The Madrid Protocol is perfect for that. And then if and as you focus on individual markets and you start generating revenue in those markets, you go back and you perfect the registration at that time. This also sort of raises through the back end the question, how long does it take? You know, if I apply for a US trademark, how long does that process take? And the answer is many, many, many months. So if you applied for a United States trademark today, it would probably take 3 months before your application is even assigned to a specific trademark examiner. And it could easily take them another month after it's assigned to review the mark and get back to you. So, you know, you're like 4 months in before anything even happens. And if the prosecution process is de minimis, like maybe they only object to 1 or 2 things, it's probably between 6 and 8 months before your trademark issues. But it is not unusual to have a trademark not issue, a registration not issue until, you know, you're 8 to 10 months out. And if you are applying in more than one trademark category, which I haven't even gotten into yet, but it could take a year. It's not unusual. So Pete, maybe with that, let's hit
Move forward. Okay. And I think there was 3 steps here.
Yep. All right. So yeah, this also circles back, Pete, to your question about when do I apply for a United States trademark? And my sort of off the cuff answers before anyone else does, but here's where we kind of break it down into the 3 steps. Applying for a trademark is not free. It will cost at least $200, probably a little bit more than that. And in general costs, and when I say $200, I'm talking about just the trademark office fees, okay? There's sort of 2 ways you can apply. One is you use the descriptions of marks already recorded in the database maintained by the trademark office, or you create your own. If you go with the cheaper version, where you don't really get to describe your mark yourself, you just have to copy something that's already in the trademark database, that will be less expensive. But long story short, assuming you do this 100% on your own without an attorney, the registration fee is still going to be hundreds of dollars. So before you spend that money, you want to do a little bit of research and sort of put your thumb on the scales to increase the likelihood that your trademark will be granted. The best way to do this is to search the registered trademark database of the Trademark Office, which is found at uspto.gov. The name of that database is TESS. The most inexpensive mark with sort of the most bang for your buck is a so-called word mark, where if like I look behind you, Brand Alive has this green stylized font that's vibrant and exciting. That would be, it could be a design or a combination word design. There might be a logo with shapes, geometric shapes, what have you, or bow and arrow, or a racing car. All of these could be part of a trademark application, but they all make the application more complicated, sort of for a mere mortal to do, and increase the benefits of working with an attorney, which if you think it's expensive to file a trademark on your own, just try and file one with an attorney. That gets real expensive real quick. So you can absolutely do the obvious Google searches on your own to see how marks are used, if they're used, and you can do a search on tests with uspto.gov. And if your mark is used, the quickest thing, if it's registered, the quickest thing to do is change your mark, come up with a different spelling of your mark, or just come up with a totally different terminology. So assuming you get past step one, which is you do the research and you see no one else has registered the mark Brand Alive, the next thing you do is file the application. This can be done on paper that you can print out from uspto.gov and mailed in, or it can be done online. Doing it online is super duper confusing because this is a form created by the United States government. Printing it off and filling it out on paper will actually allow for a more thoughtful, reflective process. One of the first things you're told online when you go to fill it out is you have 30 minutes to file this baby before you're timed out and you get to start over.
Crazy.
Yeah, and everything with the online application is going to be, in a 9-point font, super crammed together, a bunch of exceptions and notations. It's confusing. As long as you have the time to do it, maybe you want to take a few dry runs. There are ways to save your application and download it as an XML file and re-upload it. It's a train wreck that only someone who is employed full-time by the United States Trademark Office can fully appreciate and say, this is clear, this is easy. But to the rest of the world, it's not so clear and not so easy. Here's what's important, though, when you're thinking about step 2. And also going back again, Pete, to your question, when do I apply for the mark? You can either apply for the mark when you're already using the mark in business, or before you use the mark in business. The former is the preferable one, that the mark is actually being used in business. It's a so-called 1A application because it deals with section 1A of the statute. And that will require that you prove to the trademark office that you're using the mark in commerce. You'll have to submit a specimen. If you don't have a specimen, you can file with an intent to use. That's a 1B application. And generally, you have to show that intent within 6 months, although you can file extensions, and you won't be surprised to learn Uncle Sam is happy to grant you the extensions for a fee. So the process itself of applying before you're using the mark in commerce is more complicated. It's more paperwork and it's more fees. So long story short, my advice is file your mark just as you're getting ready or have just started using the mark in commerce, but not committed a lot of advertising dollars to having done so. When you apply for the mark, you will have to apply within a particular class. So if you, to pick again, a commonly known popular mark, Apple. Apple is used in computers, but not used in agriculture for the famous Apple computer mark. Interestingly, it was also, you probably know just from reading the press, that the Beatles had their music distributor
Apple Records
mark. And that was in a different class. So long story short, there are 45 international classes of goods and services. And they cover everything from agriculture to clothing to music to computers and software. And there's further distinctions, mind you, between downloadable software, which is in class 9, and cloud-based non-downloadable software as a service, which is in class 45, which is a fancy way of saying sometimes these classes are coordinated with each other. And the more classes, for each class in which you apply for your mark, you will have to give a unique and distinctive description of how and what your mark covers within each class. And for each class, you'll have to pay a separate application fee. So even if you go the cheap route, where you don't describe in your own words what your application covers, but you use a mark that, or use a description that's already in the trademark database, if you apply in 2 different classes, guess what? Now, instead of your application having to be a $200 application fee, now it's a $400 application fee. And if you want to apply in 3 classes, it's a $600 application fee. So this is how, this can snowball and get expensive quicker. One of the things I will say is if you use a description that is already in the trademark database, one of the things you will not be arguing with, more likely than not, with the trademark examiner, who's, again, remember, trying to reject your application, is your description, because by definition, it's already in there. Don't worry, that leaves a lot of runway for the trademark examiner to still have problems with your application. For example, if your mark is, I happen to live in a region of San Diego called La Costa Valley in particular. So if I apply for a trademark for the mark La Costa Goods, simply to designate that I'm in La Costa, a sharp trademark examiner will say, oh, did you know that the term La Costa is Spanish for the English word the coast, and that you cannot trademark, this foreign word? And the answer is no, I speak French, but not Spanish. And thank you for telling me that. And so then you have to, create an exception saying that you're not trying to trademark the word La Costa separate from the mark La Costa Goods, even though you have a very, there's nothing to argue with over the description of the mark. You can still argue literally over the mark itself, and a trademark examiner will find ways to do so.
Makes sense.
All right, so that covers step 2. And I think we've talked about step 3 ad nauseum. So
go ahead and advance.
Slide unless there's any questions.
All right. So you posed a question.
All right. So, I can't believe how much time I've taken up here. So I'll just ask real quick. For anyone in the audience, if you're still awake and paying attention, which one of these marks, A, B, C, or D, do you think is the most likely to be approved? And any takers?
Well, it wouldn't be B, right? Because that's so generic.
And the answer is you're right.
Okay. How about Henry or Marty? You guys have we've limited to now 3 choices.
Fernanda and I guessed C.
The answer is actually D, and here's why. You cannot get the trademark office will not issue a descriptive mark. So if you have a line of fountain pens that you have hand carved from wood and you want to call it wood fountain pens, and your description of the mark wood fountain pens is a line of fountain pens hand carved from wood, the trademark examiner in very short order will say, no, that's descriptive, can't do it. What the trademark office and what the Lanham Act and the trademark laws protect is the time, money, and resources you have put into making a word association in people's minds for your product or service that no one would make but for your efforts. So if your hand-carved wood fountain pen is called a Flamingo, but doesn't look like a flamingo, instead it just looks like a plain fountain pen, then you would absolutely get that mark registered by the trademark office because no one would think a flamingo means a fountain pen. If you, the day after your application is granted, spent $100 million advertising Flamingo fountain pens, then a lot more people would associate in their minds a flamingo with a fountain pen. And it's that association that the trademark office is then protecting. So a descriptive mark, a generic literal description of what you're trying to trademark, if that's what your mark is, it's not going to get approved. And a trademark attorney and the trademark examiner will tell you that pretty quickly. So you're going to have to come up with something creative that isn't descriptive, like flamingo for a fountain pen. Now, Flamingo Writer is on the right track, right? It may get approved. It's going to depend on the trademark examiner, but the trademark examiner may say, well, a writer, trademark Flamingo Writer, that's kind of like a pen. So yeah, you can't get the mark, you can't get the word writer approved separate and apart from the term Flamingo Writer. And that would probably be part of the negotiation process in which you're thinking to yourself, well, I don't care about protecting the word writer. Really, what I care about is the word flamingo. So yeah, I'll agree to that. I'll agree that I'm not trademarking the term writer by itself, separate from the word flamingo. If that makes the trademark examiner happy, I'm good with that. And so that may require a little bit of negotiation. Whereas if you simply try to trademark the term flamingo, a good trademark attorney may say, you know what, Henry, you want the term Flamingo Writer, let's go ahead and apply for that. But just be aware that if you apply for the term flamingo instead of the term Flamingo Writer, you may get that trademark a little bit faster. It may issue a little bit quicker because you will have taken an argument that the trademark examiner might raise off the table, and that might save you time and money.
That's great, Mike. Thank you so much for that explanation. And, from a brand expansion perspective, I like the idea of just going with Flamingo anyway, because at some point you might want to extend into other types of office things, office products, and therefore you won't have to unconfuse your audience like Dunkin Donuts has had to do with their name, switching now to just Dunkin, because donuts is so it's such a descriptor that the bagels and the coffee and everything else that they sell is a little bit clouded because of that. All right, so listen, we've got about 10 minutes. I'm going to go relatively quickly. And that's fine, because I think the part that I like the most is what Mike was talking about, because we typically talk about marketing things. And so it was great to have you, Mike, really explaining the legal aspects, which are really fabulous. So let's just go through quickly what forms of IP are relevant to us. Well, as marketers, we think about like designs and symbols and names and images that are protected by a trademark. And they serve in assisting us in creating our brand's visual identity. And then if you look at things like literary and artistic works that are protected by copyright, we use those to differentiate our products. So we might, get a jingle or some artistic other form, like a piece of art, and we're going to get an example like that, or a quote from a book or from a piece of music that will help distinguish our products. And then the third way is inventions, which are protected by patents and trademarks, strengthen our brand equity, enabling us to tell better stories. So if I can bring in an invention that makes my product stronger, more compelling, its physical attributes are enhanced, or its emotional attributes are enhanced by this particular invention, then my story has more validity to it. So this is the way that these intellectual property elements help us in our marketing efforts. And so, we as a brand owner want to retain control of the brand and stop others from using it without permission, because that's where people get confused if someone else is using your brand. Just like if someone else is using your name, that can cause a whole host of problems. And of course, we want to minimize that. And that's where, folks like Mike, who are such experts in intellectual property law, can be a huge value to us. So let's look at a case study. This is the brand Artify Life. So the Artify Life created a visual identity. And so the summary of that is listed here below. And I think, let me just go back for a second. And so the things that are described are the personal characteristics, or there's a guardrails. There's that intellectual and emotional piece that depicts action. So we look at keywords to setting this impression, and then who's that target audience that we're going after. And then what designers do is they create a mood board to help create this idea of what the brand is trying to depict. Then they look to develop a name, and then from there, then they develop a logo, which is the artistic expression of the name. And then how do we implement that identity in different products and services and marketing collateral? So in this case, we have this logo, which is Artify Life. It was for an artist and personality. Her name is Katina Zinner. Katina, I can claim as a friend. She's an amazing artist. She's also a film editor, also does that exceptionally well. And so she was creating a whole line of products that would incorporate her art. And so, the individual, Adam Herbig, who created this identity, was trying to help her, bring to life her brand. And so the tagline that they came up with was, "Don't let your food have all the fun." And here's an example of that with a apron that is her art on that particular product. And you can see her trademark in the lower right-hand side, her logo. So let's look at kind of where she came from and how she got to where she's going. So Katina not only is an artist and a film editor, but she loves animals. And you can see there she is in Africa petting a lion, which I don't think I'd ever tried doing, at least not by myself. She loves nature. She's always hiking with her dogs. And you can see those 3 Dalmatians on the right-hand side. There she is with her father as a young girl. Her father was the editor, film editor for the movie The Deer Hunter, and I believe Godfather as well, and won an Academy Award. So what was created, what was done here was to look at some brand guardrails. Who is Katina? Who isn't she? She's bold. She's confident. She's generous. She's a warrior. She's not timid. She's not ordinary. By all means, she's not ordinary. She's not obtuse. She's not negative. So this is the way to kind of put some guardrails around her brand characteristics. And then from there, come up with an initial brand expression. The idea here is when we take intellect and combine it with emotion, we get action. So what does the name represent, literally, physically, and philosophically? The name is a woman, an artist, a designer, a motivator, a leader. Emotionally, happy, inspired, curious, calm, peaceful, or alert. What action does it create or inspire us to do is to live life fully, to rise, to dream, to explore, to create, to never give up, to challenge. So from there, we come up with this thing called a positioning statement, which is, her trademark, her name, her brand as a service or a product, connecting with the target audience to fulfill a need. And so things that we look at is her vision, her purpose, and her mission. So her purpose, I seek to motivate humankind to rise and conduct life with confidence, connectivity, and compassion while improving living conditions for all human beings. So just an example of one of those three as we look at her positioning statement. So then who's the target audience? Well, mindset is more important than demographics for Katina and her art and their products. So we look at the want to feel good about their purchase from a global perspective. Design matters to them, and quality matters over price. So when we pull this together, we look at a mood board to kind of create an image to the words that we've just defined and that would directly relate to the product or service to evoke an emotion. So they create the vocabulary for your brand imagery moving forward. And so you can see these images that were used. And then, all right, what does the possible logo look like? And you can see some of the examples that were originally created. All getting around it, you can see the palette, the painter's palette, because she's an artist. That was one of the things that was looked at. There's the globe because of their global aspect. And so from there, they came up with this font style of Artify Life. And then you can see how that evolved ultimately to her existing logo today. So we wanted it to be elegant, timeless, has that Dalmatian connection because of her dogs. And so you can see here with the logo in colored version on the left and black and white on the right, the letter I is a shape of the dog's face, the two eyes and the nose, and in colors with the shapes that are elements of the Dalmatian, dots or spots. And then in the black and white version here as well. And so this is something that, we would take to Mike or someone like Mike to help us get trademarked.
And Pete, just 10 seconds.
Please.
If you just jump back real quick.
Yeah, let me do that.
That if you look at that slide, what the TM says is that it's a trademark, but it's not a registered trademark. Once your trademark is registered, you would replace that TM with a circle R. And to the extent you want to put the world on notice that a particular mark is being used by you for business, you use this TM. You don't need to file with anyone. You don't need to register with anyone, but this is going down the path of the so-called common law trademark, where you just use the term in all caps or you use this TM term after it.
Perfect. Thank you so much for calling that out, Mike. That's hugely helpful.
Yeah.
So while we're short on time, I'm just going to show you some images of how her art is applied to product. Now, I'm jumping to the gentleman, Roger Federer, who is arguably one of the greatest tennis players that ever lived. And the reason I wanted to do that was because it's important when you have a brand to be ruthlessly consistent with the way you depict that brand. And so for Katina Zinner, she needs to do effectively what Roger has done here, which is to reflect himself in every shape or form consistent with who his brand is, so that when you embed the image of who he is into the mind of your target audience, they are never confused about what he's striving for. And so this helps overall with his ability to retain that emotional state or that peace of mind that he has with his fans around the world.
So I ask you, what can you do today to make your brand come alive in the hearts of those who experience it?